Welcome to Literary and Jury Charge Practice. Get started. Ready? If, after the defendant is convicted by a jury and sentenced to prison, the victim states that he or she made the whole thing up, a typical defendant will accept if only if the judge agrees to impose the sentence recommended by the district attorney. In most cases, the judge will approve the suggested sentence, but when the crime is serious or the defendant has a long criminal record, the judge will review the district attorney's recommendations more carefully. Plea bargaining gives people an incentive for pleading guilty. It really cuts down on the number of court cases. Without this procedure, we would need thousands more courthouses, hundreds of thousands more courtroom staff members, and millions more citizens for jury duty. On the positive side, for the court reporting profession, we would need many more court reporters. Plea bargaining, however, allows the criminal justice system and everyone involved to operate at a manageable pace. Petty offenses are usually decided by a judge. Traditionally, criminal cases have been heard by 12 jurors, all of whom must agree for a conviction. A number of states now permit 6 or 8 jurors to hear the case, particularly for less serious offenses. The American system of criminal justice presumes that a defendant is innocent until proven guilty. The prosecutor has the burden of proving that the defendant is guilty and must do so beyond a reasonable doubt. This is a higher standard than that used in civil trials, where the plaintiff need only prove his or her case by a preponderance of the evidence. In some other countries, the defendant must prove his or her innocence. Before the trial, the person has the right to discover what evidence the district attorney plans to present so that he or she can prepare a defense accordingly. If the person feels that any of the evidence the district attorney plans to use at the trial resulted from an illegal search or from the failure of the police to advise the person of his or her rights, the person's attorney can file a motion to suppress the evidence. If the judge agrees and grants the motion, the district attorney will be barred from presenting that evidence to the jury at the trial. If a person feels that he or she cannot get a fair trial because of prejudicial pretrial publicity, then the case must either be transferred to another country. In legal terms, this transfer is called a change of venue. In the Rodney King case, the case was tried outside of LA because of the fear that the publicity would influence the trial. Because of the media coverage during the trial, the jury was sequestered for the duration of the trial to prevent the press from influencing the deliberations. In the Rodney King case, the jurors had no idea that so much publicity was transpiring during the course of the trial. Now we'll do a little jury charge. Ready? Members of the jury, an action of this kind is based upon a claim that the defendant has been negligent. Negligence is a failure to use the care and caution which a reasonably prudent person would exercise under the same circumstances. The reason that the plaintiff cannot recover without proving negligence on the part of the defendant is that the law says that just because an accident has occurred, there is no automatic proof that the defendant has been negligent. That is a matter which you would have to find from the testimony. On the other hand, the law holds that if a claim is presented on behalf of anybody, there can be no recovery if that particular person was himself in any degree responsible for the accident. That is what is called contributory negligence. If any negligence on the part of the plaintiff contributed to the happening of the accident, there can be no recovery. In this case, because the plaintiff died as a result of his injuries, the law presumes that he was careful and that he was not contributorily negligent. It is essential, therefore, for the defendant to prove contributory negligence on the part of the plaintiff. That will be one of the questions that you will have to take into consideration. It is your duty to determine the facts. It is your duty to reconcile the testimony as far as you can, bearing in mind the fact that no two persons remember a thing in exactly the same way. Also bear in mind that there is apt to be a little confusion on the part of any witnesses inexperienced in court when they get on the witness stand, and therefore minor differences may appear. Ladies and gentlemen, you should take all these factors into consideration in the passing upon the facts and use your best judgment as to who has been telling you the truth. Let's get back to our article on differentiating yourself as a job candidate. And let's see, we are talking about finding a mentor. Ready? My first jobs out of school were facilitated through my mentors, Carpenter says. They put me in touch with firm owners or were firm owners themselves. Carpenter's mentors vouched for her work ethic and professionalism to help get her started. You can also find mentors through NCRA's virtual mentor program, and many state associations have their own mentoring programs as well. Treat your internships like a job. Some students treat their internship as yet another requirement for graduation. Successful students, however, will treat it as a semester-long job interview and will soak up as much knowledge and experience as possible. Students have a great deal to learn to become a seasoned reporter or captioner, said Audrey Greco, Vice President of Business Development for Karash and Associates. During their internship, they have experienced all of the various types of jobs, for example, depositions, video depositions, arbitrations, hearings, classes, events, remote on-site, etc., whether it be in captioning or litigation, in order to build confidence. Your internship supervisors will be your references for jobs and may even hire you themselves if they are able. All right, we'll get back to that. Now let's get back to this legal. I don't even know if I'd call it a legal literary. It's a literary. It's a lit. Okay. Let's just read this. Ready? When you again have an opportunity to visit the continent, you are invited to inspect our new quarters. We are glad to acknowledge your letter on March 23, which states, "The balance of my account will be paid up no later than May 10 with 3 separate payments of $40 each. You should regard your delinquent account as a very important matter. We must caution you that your promise to make these payments must be carried out. If it is not, we shall be forced to take legal action. It is important to both of us. As you know, the purchasing power of money changes. By putting your savings into stocks, bonds, or similar business investments, you can protect yourself against inflation. That is why we recommend that you take advantage of a helpful plan that our bank offers, namely a living trust. A living trust arranged with the First National Bank will make available to you the services of a trained staff of trust and business personnel who will look after your interests. You will receive a regular report of your investments. On the basis of these reports, you can make objective, intelligent decisions about what investments you should retain, what investments you should increase, and what investments you should sell. After you have completed arrangements for a living trust, you need no longer worry about the financial situation of your family future. We shall welcome your request for further information. Now that spring is just around the corner, you are no doubt turning your thoughts to a new car. While you are looking over the new car advertisements in the newspapers, think of our staff of financial advisors here at the Southside National Bank. You can save by borrowing the cost of your new car and paying cash for it. In that way, you will avoid the high carrying charges that are always included in a consumer financing plan. To arrange a car loan, there are only 3 things you need to do. Namely, select the car that particularly appeals to you, discuss your needs with the head of our loan department, and choose the repayment plan that best fits your budget. Take advantage of our financing plan when you buy a new car. It is the simplest, most economical way. There is one important matter that you cannot afford to neglect. That is your will. If you have not reviewed your will recently, you make no provisions for the continued support of your family, which will be deprived of your regular income after your death. Because of its importance, your will should be planned carefully. Okay, let's get back to some jury charge practice. Ready? In other words, you pass upon the credibility of the witnesses when you do that. You may take into consideration their interest in the outcome of a case that he or she is not telling the truth. That's simply a factor for you to consider. You must use your own recollection at all times over anything I may say. It may be that I will make some innocent mistake in discussing the facts, or I may overlook something that you think is important. So you must trust your own recollection. Ladies and gentlemen, as I have instructed you, the burden is upon the plaintiff to prove by a preponderance of the evidence that the defendant was negligent. She must also prove that such negligence was a proximate cause of the injuries alleged to have been sustained by the plaintiff. The proximate cause of any injury is that cause which produces an injury and without which the result would not have occurred. It is the cause that sets in operation the factor that accomplishes or brings about the injury. Negligence is not based upon the possibility of avoiding an accident. The defendant may not be held liable for negligence merely because he might have avoided the accident had he acted differently. If the defendant did all that a prudent person would have done under the same circumstances to avoid the accident in question, the defendant is not chargeable with negligence and may not be held liable in this case. Let's read a little more from our article from the Journal of Court Reporting regarding differentiating yourself as a job candidate. And this section is on resumes. Ready? All your involvement and internships will mean nothing if your resume isn't perfect. Remember that you are entering a profession where accuracy is required, and your resume is no exception. Spell check your resume. So many times we see spelling or grammatical errors, and unfortunately those candidates do not get an interview, Baker says. Firms often have different preferences for resumes and cover letters. When approaching a firm about a job, either to be an employee or as a freelancer, it's helpful to use your network to find someone at the firm to ask what they are looking for specifically. For instance, Baker is looking for something that stands out. In order to set yourself apart with a resume in our age of technology, a video resume would be outstanding. At a minimum, put a professional photo of yourself on the cover letter. This will add a personal touch, make you relevant and different, and show your enthusiasm for working in this very rewarding and interesting profession. Certifications. Add some letters after your name to further differentiate yourself. Certifications showcase your dedication to the profession and commitment to improving yourself to be the best reporter possible. For some, certifications will be a requirement for getting hired, as clients are requesting certified providers more and more, Greco notes. Certifications can get clients' minds at ease knowing that they have hired a qualified reporter. Greco also suggests becoming a notary. Ultimately, as more reporters add certifications to their names, you must do the same or get left behind. All right. On that note, that will conclude our jury charge and literary practice.